Today is that day.
I am so sorry.
And I continue to hate myself every day, Your Honor.
I'm so sorry for the family I've hurt.
This is Ellen Frier, charged with conspiring to murder her father with the help of her 19-year-old boyfriend, Gavin McFarland. On October 2nd, 2017, 50-year-old Aaron Frier and his 15-year-old daughter, Ellen, were reported missing by Aaron's girlfriend after blood was discovered in their home. Aaron's 11-year-old daughter said she heard her father yelling that morning, but didn't come downstairs until later. She recognized Gavin's voice during the commotion. A week later, Aaron's body was found in the woods. Based on statements from Ellen's siblings, both Ellen and Gavin were brought in for questioning, and what they revealed was shocking. Ellen claimed her father had forbidden her from seeing Gavin because she was a minor and believed Gavin should know better. Aaron had also threatened Gavin, warning him to stay away. Ellen told police that her father was abusive and that she wanted to run away with Gavin. According to Ellen, Gavin arrived with 22-year-old Russell Jones, who was armed with a machete. She said Jones attacked her father and she ran away when the yelling started. However, Jones gave a different account. He told police it was Gavin who ended the life of Aaron with a baseball bat, and he only helped Gavin dispose of the body. Jones also alleged that Ellen was the mastermind behind the entire plan. Gavin McFarland admitted to taking the life of Aaron Frier, but the details that followed added a disturbing twist.
I didn't want it. I didn't want it. She wanted him, but I didn't want him. And I was like, I'm not gonna get him. She was all like, no, I don't want him around him.
Ellen falsely claimed to Gavin that her father had abused her and that she was pregnant. In reality, she wasn't pregnant, and her father, Aaron Frier, was only trying to protect her from Gavin. Gavin was later convicted of third-degree rape for having intimate relations with Frier as a minor. Gavin also revealed that Ellen had instructed him to take the life of her father, saying, "Go out in the front room, take him out, and text me when it's done." Following this revelation, Ellen pled guilty to conspiracy to commit murder and was sentenced to 25 years in prison. Gavin McFarland was found guilty of homicide and sentenced to life in prison with the possibility of parole after 25 years. At her sentencing hearing, Ellen apologized for her actions, stating that she was seeking forgiveness daily after finding God. She will be eligible for parole in 2041. Former Clark County, Indiana Sheriff Jamie Null was sentenced to 60 days in jail by Judge Larry Medlock for violating his bond conditions related to his release after charges of theft, tax fraud, and corrupt business influence. The violation stemmed from the discovery of 2 pistols in Null's home, which he was ordered to have removed as part of his bond agreement. During a tense courtroom session, Judge Medlock expressed his frustration, emphasizing Null's responsibility to ensure compliance with the court's orders.
I told Mr. Null, don't do anything stupid. Do not try to deceive me, defy me. You will not like the consequences. Today is that day. You don't interpret the law. You don't enforce the law. You're not above the law.
Despite arguments from Null's attorneys that the failure to remove the weapons was an honest mistake, the judge held Null accountable, highlighting that compliance was solely his responsibility. Null had previously enlisted his brother-in-law and another individual to remove weapons from his home, leading to the collection of 82 firearms.
I collected the that I saw, yes, sir.
And you felt like you got them all?
I felt like I got the where he directed me to find.
However, the 2 pistols, still in their factory packaging, were overlooked and later found during a search warrant execution. Null's defense argued that the oversight was unintentional, but the judge dismissed this defense as insufficient.
People make mistakes, of course they do. But we know that those guns have been purchased since 2017 and they're in the same box, haven't been disturbed, haven't been out.
Every time I go into court, I hear, I didn't know it was there. I didn't know it was there. Take him into custody.
Judge Medlock's stern response included a powerful reprimand of Null, breaking the gavel block on his bench in the process.
What is an appropriate sanction? You know what I think the answer is? 60 days in. That's what I think the answer is today. I told Mr. Null, don't do anything stupid. Do not try to deceive me, defy me. You will not like the consequences.
He emphasized that Noel, a former law enforcement officer, is not above the law. Aubrey Davis, a 26-year-old woman nicknamed the Bail Bond Queen, faced a day of reckoning in court after accumulating a staggering 16 bonds in just over a year.
You, Aubrey Donnell Davis, For doing this almost 20 years, I've never had a client that had this many bonds, period.
These bonds stemmed from numerous theft and robbery charges across several counties, including the theft of 243 cans of baby formula and a robbery at a Subway where an employee was seriously injured.
She is a career habitual thief. Bottom.
Despite being given multiple opportunities to reform, including a probation sentence in June, Davis repeatedly violated the terms of her probation.
And I told you in no uncertain terms that if you broke or violated any of those terms that you would go to a Texas prison.
She gave her an opportunity to, get her life straightened out. She gave her multiple chances, and Aubrey Davis blew every single one of them.
Unfortunately, she had been involved with folks that were getting her addicted to. She suffered through a miscarriage. She had some psychological issues that she was working through, but nevertheless, she was given the opportunity. Unfortunately, she didn't take advantage.
Her defense cited struggles with addiction, a miscarriage, and psychological issues, but the judge ruled that Davis failed to take responsibility and make changes when given the chance.
I'm going to order that you do your state jail time, which is flat time up to 6 months, before you begin your prison sentence. Do you have anything to say? You want to apologize now?
The judge, and rightfully so, and we applaud the judge.
I better never see you here again. Do you understand? All right, take her away.
For her crimes, visiting Judge Vanessa Velasquez sentenced Davis to 180 days in state jail for theft, followed by a 5-year prison term for robbery.
Assess your punishment at 180 days in a state jail facility. I am not going to give you any credit, and I'm not going to give you 20% credit on that.
Davis was also ordered to serve her state jail sentence first, with no credit for time served. The judge emphasized that this was Davis's final chance, warning her not to appear in court again. However, Davis's legal troubles are far from over, as she still faces charges in 4 other counties. Our next case is about Centoya Brown and highlights the tragic impact of trauma and the flaws in our justice system.
One time, the first time he did something to me is when he and I passed out because he said I thought he was a joke.
Centoya Brown was born to a mother who struggled with drug addiction, making her life challenging from the beginning. Unable to care for her, her mother decided to give her up for adoption. She was later adopted by caring parents.
What else did he do to you?
He talked real bad to me and jacked me. He pulled me by my hair and dragged me and stuff. He put me, told me and stuff like that, getting that out of other people.
Centoya Brown faced many struggles in her life. As a young teenager, she made some poor decisions that resulted in her being placed in the custody of the Department of Children and Family Services. Trying to escape her situation, she ran away and ended up homeless on the streets of Nashville.
She granted Berman access to the then teenager all the way through her criminal trial.
While living on the streets, Centoya fell into the hands of a predator who exploited her vulnerability and forced her into trafficking. On August 6, 2004, she had a life-changing encounter with Johnny Allen, a 43-year-old real estate agent and Sunday school teacher.
Hit me or do something like that, but then he rolls over and reaches, like he's reaching to the side of the bed or something, so I'm thinking, oh, he's not finna hit me, he's finna get a.
And what did you do at that time?
I just grabbed the and I shot him.
Centoya said she agreed to have intercourse with Johnny Allen for $150, but according to her, it never happened. She claimed that at one point, she thought Johnny was reaching for a weapon. Out of fear, she grabbed a weapon from his nightstand and fired at him in the back of the head, ending his life instantly. Panicked, she took $172, 2 weapons, and fled the scene in his truck. Despite being a minor, Centoya was tried as an adult, sparking debate. The Metro Juvenile Court judge justified the decision by saying Centoya was too dangerous to remain in the juvenile system. Centoya said she acted in self-defense, claiming Johnny had intimidated her by standing over her while she was in bed. The prosecution argued otherwise, saying Johnny was found in a sleeping position and claiming Centoya ended his life while he was asleep to rob him. During the trial, 3 inmates testified that Centoya had confessed to harming Johnny and even said she felt satisfied about taking a life. Another inmate produced a letter she claimed was written by Centoya, where she allegedly admitted lying to police about parts parts of her story. According to the letter, Centoya said everything she told police was true, except for the detail about thinking Johnny was reaching for a weapon. A forensic document expert examined the letter and said it matched Centoya's handwriting, raising doubts about her credibility and leaving the jury to question her version of events.
60 years behind bars. Even with good behavior, Brown would have to serve at least 51 years before any chance of parole.
Yeah, it's over with now.
Centoya's defense argued that Johnny had intended to assault her, though they did not claim she acted in self-defense. They brought forward witnesses who testified about Johnny's troubling behavior toward women. One witness said Johnny took her to his home, kissed her against her will, and assaulted her after she refused to be intimate with him. The jury found Centoya guilty of first-degree murder, felony murder, and aggravated robbery, resulting in a life sentence. This outcome was especially shocking due to her young age at the time of the conviction. In 2018, the Tennessee Board of Parole held a hearing for Centoya's clemency petition, where witnesses who knew her were allowed to testify in her support.
I just wanted to say thank you. I know a lot of people get to see you, but I have prayed for a very long time.
Centoya's hearing was held on May 28, 2018, with her future at stake. After months of deliberation, on January 7, 2019, her life sentence was commuted to 15 years in prison, followed by 10 years of supervised parole. This marked a significant turning point in her life, giving her the opportunity for rehabilitation and a chance to reintegrate into society. The judge overseeing the case emphasized the importance of hope and second chances, highlighting the potential for redemption. Johnny's family, still grieving his loss, strongly opposed the decision, believing justice had not been served and that her life sentence should have remained in place. Officers involved in the case echoed their sentiments, viewing her release as a miscarriage of justice.
She is someone that has completely rehabilitated herself.
The president granted Johnson's pardon, saying those who pay their debt to society and better themselves in prison deserve a second chance.
Since her release, Centoya Brown has become an advocate, speaking out about domestic minor exploitation and the justice system's treatment of young offenders. She has traveled across the country as a keynote speaker, sharing her powerful story of survival and resilience to inspire and educate others. In 2020, Gabriel Gagos lost his life due to the actions of Mariano Campos Jimenez, who was driving under the influence of alcohol. Campos Jimenez admitted to the crime and, after a prolonged legal process, accepted a plea deal in May, leading to a 10-year prison sentence.
I'm extremely agitated that we have to be back up here today.
However, just 6 months into her sentence, she petitioned for shock probation, which would allow her to complete her sentence outside of prison.
We're victims here, okay? You talk about all the individuals that you've helped. You know what you can do for us? Your sentence. Time served.
During the emotional hearing, Campos Jimenez apologized to Gagos' family and expressed a desire to further her education and contribute to society.
I want the opportunity to go back to work, to further my education and pursue a master's in social work, and to give back as much as I can to the community. I am so sorry. I am sorry. Please forgive me.
However, her apology and request were met with strong opposition from Gagos' family, who expressed their grief and frustration, stating that 6 months behind bars was insufficient for the loss of their loved one.
We're here 6 months, less than 180 days. And we're back in this courtroom because you're having difficulty.
They emphasized the devastating impact of her actions and called her behavior a criminal act rather than a mistake. The presiding judge, Judge Pevas, ultimately denied Campos Jimenez's motion for shock probation, ensuring she will serve the remainder of her 10-year sentence in prison. She will be eligible for parole after serving at least 5 years.
She is doing 10 years in prison, but Mr. Gallegos is in the dirt. And the sooner you accept that's what you did. You see, someone said that Mr. Gallegos, he didn't, you, that's not a mistake. It was a criminal act.
Gagos' family expressed relief at the decision, but emphasized their continued pain and loss. Eileen Alderette, 25, was sentenced to 26 to 65 years in prison for the DUI crash that claimed the life of Levi Akeniki. The crash occurred when Alderette, driving at over 100 miles per hour while under the influence, ran red lights and collided with the car carrying Levi and his parents. She pled guilty to second-degree murder and 2 DUI charges. The courtroom was filled with emotional testimonies from Levi's grieving family, including his 12-year-old brother, Joey, who pleaded with the judge for the maximum sentence.
I just can't control myself. What she did was not right at all. Like my mom said, the best birthday present that my brother could get.
Levi's parents described their profound loss and heartbreak, emphasizing how Alderette's reckless decision destroyed their lives.
My entire life was flipped upside down and ruined by her decision to drive.
Her family can at least still visit her. My baby boy was he.
I'm so sorry. People say, forgive and forget. We choose not to forgive her. We choose to forget her.
During the sentencing, Alderette wept continuously and apologized multiple times to the family, but her apologies were met with rejection as the family expressed their inability to forgive her.
I'm so sorry for the family I've hurt.
The court was shown a video of Alderette running a red light before the crash, underscoring the recklessness of her actions.
Oh my God.
Prosecutors argued that apologies were insufficient and emphasized that her punishment was necessary, as education and remorse had not prevented her actions.
Done trying to teach you the error of your ways, and now you're going to be punished. And if education didn't work, perhaps the fear of God will.
Family can still see her wherever she may end up. We visit our son at Palm Mortuary.
Levi's family plans to honor his memory by cutting a cake on his upcoming birthday, though he will no longer be there to celebrate with them. On April 21st, 2022, Trayvon Singleton, whose brother lost his life in Garfield Heights the year before, attacked the individual responsible during the sentencing in a Cuyahoga County courtroom.
Take it easy. Take it easy. Are you relaxed now? All right, give him your hands. All right. Just give him your hands. All right. My hand in the way. Put your fingers. Leave fingers. All right. All right, we can get you up now. Pick your knees up. Up to your chest. Help him get yourself up. All right, stay right here. I gotta go back. Take it to the back. All right. Take him in the cell right now. Put him in the cell. Okay. All right. Don't move, man. Do not move. Got it? All right. Don't even move. Double up those cuffs and close the door. Stay there. What? Yeah, I'm good.
Trayvon grabbed Jalen Barson by the neck and tried to choke him. Judge Andrew Santoy paused Barson's sentencing and held a contempt of court hearing for Trayvon Singleton. The judge found Trayvon guilty of contempt and gave him a 15-day jail sentence.
Hey, are we playing the floor? Sorry, we playing the floor. There's the floor. And everybody to exit down to the first floor, please. Everyone exit to the first floor. If they were called in the abscess, let them know we're going to be sending out a bunch of people. Gotcha. What happened? My switch got shut off. They were calling the victim's family to speak. He basically rushed the defendant. And we grabbed him. Rushed the defendant. Got in back cell. One of the victims. Court staff owes you. Go ahead. We're going to be sending down a lot of family from the 21st floor. All of them need to leave the building. Everyone from the 21st floor we're sending out needs to leave the building. Family number one. No. Are the who's the prosecutor on this case? Schnatter. Yeah, I need to find out.
On Friday, Judge Santoy continued the sentencing hearing and sentenced Brabson to a minimum of 25 years in prison. During the arraignment of Matthew Komrowski, charged with the murder and kidnapping of his girlfriend, Shirley Donnelly, tensions escalated in the courtroom. As Komrowski was being escorted out, Shirley's ex-husband, Raymond Donnelly, lunged at him, prompting deputies to intervene and clear the courtroom.
Preliminary results of the medical examiner indicate the manner of death as a homicide.
Family members expressed their anger, especially after Komrowski suggested they would assist with his bail.
Yeah, I think their family is gonna help.
Denise Donnelly, Shirley's sister-in-law, emphasized the family's disbelief and sorrow over the incident. Komrowski, who had a prior criminal record, was apprehended approximately 23 hours after the crime. Authorities discovered Shirley Donnelly's body in her Cranston apartment following a fire that appeared to be intentionally set to cover up the homicide.
It was more than that. It was arson, domestic, attempted murder, assault. It went on and on and on.
Komrowski was located at his sister's residence in Providence and taken into custody after a brief struggle. Devin Spraggins, 24, was sentenced to 39 years to life in prison for the 2022 incident involving NYPD Detective Brett Bowler in Queens, where he was critically injured. The incident occurred after Spraggins got into a physical altercation on an MTA bus and fled when officers, including Bowler, intervened. During the chase, Spraggins fired at Bowler, hitting his leg and shattering his hip, and attempted to fire again while he lay defenseless on the ground. The weapon malfunctioned due to a missing magazine, preventing further harm. Spraggins escaped in a livery car, but was apprehended in a Bronx apartment shortly afterward.
My son was on the job, out in the street, 3 months.
In court, prosecutors highlighted the premeditated nature of the crime and its devastating impact on Bowler, who suffers from lasting physical pain and career disruption.
The defendant stood over Detective Bowler's defenseless body on the ground and tried to execute him by attempting to him a second time. He begged his partner to keep his eyes open because he was terrified that if Detective Bowler closed his eyes, that he would.
His partner, deeply shaken, left the NYPD. Spraggins, with a history of violence, including a prior rape conviction and assaulting an inmate at Rikers Island, showed no signs of rehabilitation, according to the judge.
Permanently injured and altered the career path of Police Officer Bowler, who may have gone on to do great things for this city in that role.
Despite his attorney's argument about a troubled past, the court emphasized his choices and their consequences, sentencing him to ensure public safety and justice for Bowler and his family. Former Mesa County, Colorado, Clerk Tina Peters was sentenced to 9 years in prison after being convicted on multiple charges, including attempting to influence a public servant during the 2020 presidential election.
Good. Well, so you know what I'm saying is true. It's not funny. My life is on the line here, Your Honor.
During her sentencing, an emotional Peters insisted she was not a criminal and expressed remorse, though her claims of innocence and regret were met with skepticism.
Not a criminal. And I don't deserve to go into a prison where other people have committed heinous crimes. The only crime that I did, and some people have said I'm not remorseful. Yes, I'm remorseful. Yes, sir.
The court exchange became contentious when Peters accused the judge of believing allegations against her, prompting Judge Matthew Barrett to refute her claim and express his frustration.
You're the one who's making this allegation that one,
it's
I think
not
is
an
funny,
allegation.
and two, that I know it's true. You're saying that as if I believe you, and I did not say that.
Okay.
That is why I made the sound, because it's insulting to me for you to just put that in a record in front of all of these people that I believe something to be true.
Okay, and I apologize for that.
The case against Peters included body camera footage of her resisting arrest in 2022, which added to the evidence of her actions.
Let go of me! Do not resist! Let go of me!
Despite her tearful statements, the court held her accountable for her misconduct, emphasizing the importance of integrity in public office. In 2002, a murder known as the Jack in the Box murder remained unsolved for many years. On May 2, 2002, a blueberry farmer noticed burnt trees while driving on his property. Approaching, he discovered an open footlocker containing the charred remains of a man. The police arrived and collected evidence but could not identify the body, and the case went cold. In 2015, the victim was finally identified as 37-year-old Roberto Carabello. Roberto's last known relatives were his wife, wife, Beverly McCallum, her daughter, Dylann Ducharme, and their daughter, Cicely Carabello. The police questioned Beverly, Dylann, and Cicely. Dylann eventually told the police that her mother and a man named Christopher McMillan had helped her murder Roberto. During interrogation, McMillan revealed that Beverly had pushed her husband down basement stairs and then beat him with a hammer until it got stuck in his skull. While Roberto was still alive, Beverly suffocated him with a plastic bag. According to McMillan and Beverly's daughter, Beverly had planned the murder as a test run for becoming a serial killer. Dylann and McMillan both admitted to participating in the murder and dismemberment of Roberto's body. Dylann was convicted of first-degree murder and received a life sentence. Christopher McMillan was sentenced to 15 to 40 years in prison. Beverly avoided the authorities for 5 years after Roberto's body was identified and was finally arrested in Italy in 2020. She was extradited to the US and her trial began. Beverly was portrayed as dangerous, and prosecutors argued she harmed Roberto because he interfered with her lifestyle. She was charged with second-degree murder and mutilation of a body. In court, she appeared uninterested and showed no remorse. Despite her claim that her daughter was the murderer, this was not believed. Roberto's now 31-year-old daughter made an impact statement, asking the judge for the maximum sentence.
This must be served not only for my father, but for those who have forever been changed by her ruthless actions. I formally request restitution and intend to utilize all proceeds to help support children of murdered parents.
Despite her daughter's testimony, Beverly McCallum appeared emotionless, uninterested, and even nodded off during her attorney's closing arguments. She maintained this indifferent attitude when the jury delivered their verdict. The judge noted her inability to comprehend how someone could show no remorse. Ultimately, Beverly was sentenced to 40 to 60 years in prison. Her callous behavior shocked everyone. Jamie Komorowski was sentenced to a total of 30 years in prison for her role in a tragic DUI crash that claimed the life of Samantha Miller, 34, on her wedding night and critically injured Miller's husband, Eric Hutchinson. Komorowski pled guilty to 3 counts of felony DUI and 1 count of reckless homicide. The crash occurred in April 2023 when Komorowski, while driving under the influence, struck a golf cart carrying the newlyweds shortly after their wedding reception. During the sentencing, the judge addressed Komorowski's behavior and the details of her case. She was sentenced to 25 years for the felony DUI resulting in death and 15 years each for 2 felony DUI charges involving great bodily injury, with all sentences to run concurrently.
Been presented to the court, and I have taken into consideration the mitigation that has been presented. And based on what has been presented to the court, I find the following appropriate in the nature of sentencing. On the offense of reckless driving, reckless homicide, which is 2023 GS 103895, you're sentenced to the State Department of Corrections for a period of 10 years and $5,000, provided upon the service of 10 years. Yeah. On both counts of felony DUI, great bodily injury, you're sentenced to the State Department of Corrections for a period of 15 years and $5,100, provided upon the service of 15 years. And on the offense of felony DUI with death, you're sentenced to the State Department of Corrections for a period of 25 years and $10,100, provided upon the service of 25 years. These sentences are concurrent with one another. You'll get credit pursuant to 241340 if that becomes applicable. And I think it is appropriate, and I queried Mr. Finch for a particular reason. It was not random. Our state legislature, in their infinite wisdom.
Additionally, she received credit for time spent on monitored house arrest, which the court considered akin to being in jail at home.
Amended 241340 to allow for time spent on monitored house arrest. And it was contemplated that a person get credit when they are basically in jail at home. And based on how Ms. Komorowski's home detention was structured, she was in jail, but for being at home. And I think it is appropriate that she receive credit for any time served on monitored house arrest or home detention. Those terms in my mind are interchangeable. From the period of 3/1/2024 through the present, and we'll calculate that and place it on her sentencing sheets. Again, these sentences are concurrent. I've ordered the ATU if it is available to her, and she will get credit for any time served pursuant to 24-13-40. Thank you all for your time and your attention today. Have a good afternoon. And I will leave the clearance of.
The emotional hearing included statements from the victim's family, expressing their grief and loss. Komorowski's sentence reflects the severity of her actions and their devastating impact, with the court emphasizing the importance of accountability in such cases. This woman keeps interrupting the judge, but the judge knows just how to deal with her.
Ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I would like to call.
Ma'am, stop. I know you want to control this room, but this isn't Burger King. When the sign changes to Burger King, you can have it your way. Right now, this is my courtroom, and you will answer my questions. Stop. Do you promise to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Yes or no? Are you going to tell the truth? All right, I'll take that as silence. I understand her attorney is on here. Where is her attorney? Again, say anything again without telling me you're going to tell the truth, and I will hold you in contempt of court for 93 days. Contempt carries with it 93 days and or $7,500. You will not act disrespectful in this court. Do you understand, ma'am? You certainly may remain silent. Where is your attorney? Do we have an attorney?
I'm here.
Sir?
You do, Your Honor.
The judge put this woman in her place, and it seems like she got the message. When he lost faith in the justice system, this prosecutor felt he had no option but to call for help.
Sorry, but I would object to going forward anyway right now without the elected county prosecutor who's on this case.
But she chose not to be here.
That's not accurate, Judge.
Okay, okay, your objection's noted.
We had a phone status conference 2 weeks ago in which Ms. Schiff will...
Your objection is noted. Okay?
I'm not going to participate in this proceeding without the elected county prosecutor. I think this is a sham that you're going forward. When the court was...
You're going to sit here. You're going to sit here.
You were told about her unavailability and specifically told her on the phone not to cancel that appointment, that it wouldn't be a problem.
Well, I'll tell you what. If you want to be here for the decision, that's your business.
Well, Your Honor, I think this is outrageous. You're going forward without the prosecutor.
I've prepared my remarks and my decision here today. And I am, I am glad I had the opportunity to spend the night to do some deliberation on this matter and think.
It makes you think about how often these kinds of arguments affect the justice system. Jason Thornberg, a 44-year-old man, was convicted and sentenced to death for the brutal murders of 3 individuals, David Lueris, 42, Lauren Phillips, 34, and Maricruz Reyes Mathis, 33, in September 2021 in Texas. Thornberg lured each victim separately to a motel room he rented in Euless, Texas. In a disturbing act of violence, he dismembered their bodies, stored the remains under his bed, and later burned them in a dumpster. Thornberg admitted to the acts, claiming he was called to commit sacrifices for religious reasons.
Presiding juror, has the jury reached a verdict?
Yes.
All right. And the verdict form. All right. Were your answers unanimous?
Yes.
All right. Verdict is as follows. Special issue number 1, do you find from the evidence beyond a reasonable doubt that there is a probability that the defendant would commit criminal acts of violence that would constitute a continuing threat to society Answer. We, the jury, unanimously find from the evidence beyond a reasonable doubt that the answer to special issue number 1 is yes. Special issue number 2. Taking into consideration all of the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, do you find that there is sufficient mitigating circumstance or circumstances to warrant that a sentence of life imprisonment without parole rather than a death sentence be imposed? Answer. We, the jury, unanimously find that the answer to special issue number 2 is no.
Afterward, he meticulously planned to cover up the crimes, disposing of the remains, burning them, and cleaning out the containers used for storage before returning them to the store. During the investigation, Thornberg also confessed to earlier murders, including his roommate Mark Jewell, who passed away in a suspicious gas explosion in May 2021, and his girlfriend Tanya Bigay, who disappeared in Arizona in 2017.
Ladies and gentlemen of the jury, a poll has been requested, so I'm going to call out your juror number, and I'm going to ask you if this is your verdict. Juror number 3, is this your verdict?
Yes.
Juror number 5, is this your verdict?
Juror number 6.
Ms. Fregoso?
Yes.
Juror number 17, is this your verdict?
Yes.
Juror number 34, is this your verdict?
Yes.
Juror number 46, is this your verdict?
Yes.
Juror number 74, is this your verdict?
Yes.
Juror number 89, is this your verdict?
Yes.
Juror number 93, is this your verdict?
Yes.
Juror number 96, is this your verdict?
Yes.
Juror 113, is this your verdict?
Yes.
Juror 131, is this your verdict?
Yes.
Juror 159, is this your verdict?
Yes.
Defense counsel, is there any reason why a sentence should not be pronounced? Any legal reason?
No legal reason, Your Honor.
Thornberg claimed Bigay was also a sacrifice. The FBI continues to investigate Tanya's case as her body has not been recovered. At his trial, the prosecution presented evidence of his calculated actions, including his attempts to cover up the crimes, arguing he was fully aware of his actions. Thornberg's defense argued that he suffered from severe mental illness and delusions, suggesting he was not in control of his actions.
Therefore, Jason Allen Thornberg, you have been adjudged by a jury to be guilty of capital murder, and the juror has answered the special issues, making it mandatory that your punishment be death. Therefore, this court sentences you, Jason Allen Thornberg, to death. The clerk of this court shall no later than the 10th day after this court enters its order setting the date for execution, issue a warrant under the seal of this court for the execution of the sentence of death, which shall be directed to the Director of the Correctional Institutions Division of the Texas Department of Criminal Justice at Huntsville, Texas, commanding the Director to proceed at the time and place named in the order of execution to carry the same into execution. This sentence shall be executed at any time after the hour of 6 p.m. on the day set for the execution by intravenous injection of a substance or substances in a lethal quantity sufficient to cause death and until you, Jason Allen Thornberg, are dead. Such execution procedure to be determined and supervised by the Director of the Correctional Institutions Division of the Texas Department of Criminal Justice. The judgment of conviction and sentence of death are subject to automatic review by the Court of Criminal Appeals. No date shall be set for the execution of sentence until after receipt by the clerk of this court of the mandate of affirmance of the Court of Criminal Appeals. This court will appoint counsel to represent you on the appeal and to apply for writ of certiorari to the United States Supreme Court if appropriate. Your counsel will be furnished a copy of this record, of the record of this case at no cost to you. And earlier this afternoon, I did appoint Mr. Robert Gill as your attorney on the appeal. Mr. Gill, will you please make sure that your client is aware of his appellate rights?
Yes, sir, I will.
Thank you.
However, the jury rejected this argument and deemed him a future danger to society, sentencing him to death. The families of the victims expressed their grief and support for the death sentence, citing the gruesome nature of the crimes and Thornberg's lack of remorse. Thornberg will remain in prison in Huntsville, Texas, awaiting his execution. Robert Linscott, a 68-year-old man, was sentenced to 1 year in jail and 36 months of probation for felony aggravated indecent exposure following incidents at the What's the Scoop ice cream shop in Georgetown Township, Michigan. Linscott, who has a history of similar offenses, exposed himself to 2 young employees during 2 separate visits to the shop on June 23rd and July 28th of this year.
Thank you. The court had the opportunity also to review the pre-sentence report that was conducted in the Hudsonville District Court a few years ago as a result of misconduct. So in reviewing your record, it appears that you had an indecent exposure conviction in 2015. You were sentenced to probation and jail for 90 days with a 5-day review. It looks like you did the 5 days, so the balance of that jail sentence was suspended and the discharge was termed a successful probation. In 2020, there was the conviction in Hudsonville, which I just mentioned. You got 30 days in jail. It looks like you only did 1 day in jail at that particular point in time. So the balance of the jail time was suspended. You did 12 months of probation. There was a 3rd and a 4th incident in Hudsonville as well. They were dismissed as part of that agreement back in 2020. So we had at least 4 victims up until that point in time. Now we have 2 separate exposures here involving 2 additional victims here. So we have 6 victims over 10 years.
Despite his past convictions for indecent exposure in 2015 and 2020, where he served minimal jail time and was placed on probation, Linscott continued to reoffend. His 2020 pre-sentence investigation had classified him as a low-risk sex offender, but the judge deemed that assessment inaccurate, given his repeated misconduct.
You've completed probation. It was described as a successful completion of probation. I guess that's debatable whether it was successful or not, because apparently you didn't learn from your misconduct, didn't learn from a sanction. So in reality, probation is not successful at all. As part of that 2020 pre-sentence investigation report from Hudsonville, I also reviewed risk assessment that was conducted. You were described as low risk. Obviously that was wrong. You know right from wrong. I mean, let's face it. You're mature, you're not youthful. This was done to youthful indiscretion. Low level of sanctions apparently don't work for you. This affects the quality of life for a community. It really does. So this needs to be sanctioned appropriately, especially when we have a repeat offender who, in spite of very reasonable treatment by the district court, you continue to reoffend. So, okay, that's what you're going to get.
During sentencing, the judge noted the impact on the victims and emphasized that Linscott had not learned from prior sanctions, necessitating a harsher sentence to protect the community.
In the misdemeanor file 2446890, this is a 1-year misdemeanor charge. That's what you were convicted of. It's 365 days in the Ottawa County Jail. You must pay state costs, crime victim costs. In file number 889, this is the felony case. The aggravated indecent exposure. It is the sentence of this court that you be placed on probation for 36 months, 180 days in jail, credit for 30 days previously served. Must pay state costs, crime victim costs, and DNA fees that are required by statute. Attorney fee reimbursement of $300. The balance of the terms of probation will be on a written probation order that you will receive shortly. These are final sentences. You may file an application to the Court of Appeals regarding your conviction and sentence. If you're unable to hire an attorney, this court will appoint one to represent you at public expense. You need to fill out the paperwork you've been provided, return it within 42 days. I also note I did receive a victim impact statement, and your misconduct significantly adversely affected a member of our community, and she's entitled to be protected. That is all. Thank you.
The incidents at the ice cream shop came to light after employees provided a photo of Linscott during his second visit, leading detectives to identify and arrest him. Linscott pleaded no contest to the charges and expressed remorse in court.
Felony file 180.
Pardon me?
180.
890. I'm sorry, it's the other one. Yeah, you're right. You're right.
180?
Yeah.
Any time credit?
Pardon me?
Was it 30 days credit?
30 days credit on both, and they're concurrent.
Thank you.
However, the judge highlighted the harm caused to the victims and the community, as well as Linscott's persistent pattern of reoffending despite prior leniency in sentencing. Brandon Ortiz Vite was sentenced to a minimum of 39 years and up to 100 years in prison for the murder of 25-year-old Ruby Garcia in Michigan. Ortiz Vite pleaded guilty to second-degree murder, carjacking, carrying a concealed weapon, and felony firearm charges as part of a plea deal. His sentences include 2 years for felony firearm charges and a minimum of 37 years for second-degree murder, served consecutively. He also received sentences for carjacking and carrying a concealed weapon, which will be served concurrently with his primary convictions.
Sir, you ended up pleading guilty to a felony firearm, which carries a maximum penalty that must be first of 2 years. It must be served first. Then you pled guilty to a second-degree murder, which carries a maximum penalty of life or any term of years. You also pled guilty to carjacking, which carries a maximum penalty of life or any term of years, as well as carrying a concealed weapon, which carries a maximum penalty of 5 years. You're 26 years old, you have some prior misdemeanors, you've been in jail at least twice, and you've been on probation before. This was a situation, sir, where you took the life of Ruby Garcia, who was a young lady who had everything in front of her. You were arguing with her. This was on US 131. You ended up her multiple times. She was shot in the chin, the left temple, the upper arm, the hand, the head, and you started when you were in the car, and then you took her out of the car, put the gun to her head, and pulled the trigger and shot her again. There is just no justification or excuse for this. Your sentencing guidelines call for a minimum sentence between 171 months and 285 months, also 19 to 38 months, or 270 months to 450 months on the second-degree murder, and that's a range of 22.5 years to 37.5 years for your minimum sentence. There is an agreement that your attorney reached with the prosecutor in this morning that I will, in this incident, that I will follow, and that is that you would first receive 2 years on the felony firearm, and then somewhere in a range of 30 to 37 years on your minimum sentence on the second-degree murder. This, sir, was a cold-blooded, intentional. This young lady several times, and then you put the gun right to her head and pulled the trigger. There is just no reason for this, no justification, no excuse whatsoever. You, sir, are a cold-blooded. This is an intentional crime, and you are a danger to society. You are a very violent individual, and you need to be removed from society. It is the sentence of this court that, first of all, you be committed to the Michigan Department of Corrections, serve a minimum of 2 years on the felony firearm. After that, you will serve 37 years to a minimum of 100 years on the second-degree murder. Concurrent to those, you'll serve 20 years to 80 years on the carjacking and 3 to 5 years on the carrying a concealed weapon. You're entitled to credit of 228 days. There's $272 in state costs, $130 crime victim assessment, $1,000 in court costs. Accordingly, this is the final sentence of the court. You're receiving a form that explains your appellate rights. Sir, I hope every single night you think about the damage that you did to this family and what you did to this young lady. Please take him out of here.
The tragic case involved Ortiz Vite fatally injuring Garcia multiple times on March 22nd, leaving her body on US 131. He then stole her car, which was later found with bullet holes and bloodstains. 2 days later, Ortiz Vite called 911 from a church and confessed to the murder. Ortiz Vite had a complex immigration history, having previously been approved for the Deferred Action for Childhood Arrivals (DACA) program, but deported in 2020. His illegal re-entry into the U.S. surfaced during the investigation, and he may face deportation again after serving his sentence. While Garcia's murder drew significant media attention, Kent County Prosecutor Christopher Becker emphasized that the case should be viewed as a domestic violence incident, noting the sensitive nature of the situation for Garcia's family and the potential harm of politicizing the tragedy. Ruby Garcia, remembered fondly by her loved ones, was laid to rest in March. The case of Natasha Ellis received sensitive media coverage due to its shocking nature. At 15 years old, Ellis assisted her 13-year-old friend in attacking the friend's family on May 23, 2019. Ellis entered the home and carried out the attack as instructed by her friend. The friend's mother, 36-year-old Lee A. Moore, tragically lost her life in the attack. The father, Paul Grier, and the then 17-year-old brother were also injured but survived. Ellis fatally stabbed Lee A. Moore, and Paul Grier sustained severe stab wounds to his arms, requiring bandages for over a year. Ellis's friend provided the weapons and directed her on what to do. Evidence showed the two were in contact right up until the murder and attempted murders occurred. Both girls were arrested and charged. Ellis was tried as an adult and faced charges of murder, attempted murder, aggravated assault, and felonious murder. No clear motive was identified for the attack. 7 months later, Ellis pleaded not guilty by reason of insanity, though she was found competent to stand trial. During her sentencing, Ellis cried and apologized to the victims, saying she never wanted anyone to be hurt.
Well, you know, I'm sorry for everything that happened to you and your family. I'm sorry for being tough on you. All everyone's feeling, don't you have a lot.
Ultimately, she was sentenced to 15 years to life in prison, with a minimum of 22 years to be served before she is eligible for parole. In October 2015, 22-year-old Brianna Smart from Auburn Hills, Michigan, was involved in a shocking incident with law enforcement. On October 23rd, Officer Martin Mikolajczak pulled her over for driving with a suspended license. When he tried to arrest her, Brianna resisted, got back into her car, and reversed it, hitting the officer and pinning him against his patrol car. She then drove off without offering any help. Officer Mikolajczak suffered serious injuries, but survived the incident, which could have been fatal. Brianna was arrested shortly after and faced serious consequences for her actions.
This officer was trying to arrest this woman for driving with a suspended license. That would have been a misdemeanor, but in trying to avoid that arrest, she just got herself into a whole lot more trouble. 22-year-old Brianna Rochelle Smart got teary-eyed in court as the judge read the felony charges she's facing after trying to escape arrest early this morning.
The officer went to the hospital today.
She's charged with fleeing and eluding police, resisting and assaulting a police officer, and felonious assault with a motor vehicle, all because she wanted to stay out of jail.
If Brianna had followed Officer Mikolajczak's instructions as she was supposed to, she would likely be facing a far less serious charge and might have even avoided jail time. However, her disregard for the officer's life now means she could be facing decades in prison.
She then struck his vehicle, which caused her to stop and the officer to fall to the ground, and then she sped off at a high rate of speed.
Her vehicle was found about half a mile away. Police think she got picked up and taken to a home in Auburn Hills, where she was arrested before noon.
During her first court hearing, Brianna broke down in tears as the judge criticized her actions.
Told the judge she works 2 jobs and lives alone with her kids, but she was given a stern warning.
I don't want you driving any motor vehicle whatsoever. Not even a moped. Are we clear on that?
A misdemeanor snowballed into a 3-fold felony that could have been avoided with some cooperation.
In December 2015, Brianna pleaded no contest to several charges, including assaulting a police officer, fleeing and eluding assault with a dangerous weapon, and driving without a valid license. Before her sentencing, she tearfully tried to apologize for her actions, but not before the judge once again reprimanded her.
Yes, I would like to send my deepest apologies to his office. I never meant for none of this to happen this October 23rd.
No, let's back up. You did. Your actions were all deliberate, okay? There were This isn't the time to make excuses or to justify anything you did. You need to own it.
Okay.
What you did was deliberate.
All right.
You not only ran into that officer, you ran into his vehicle, and then you took off. Not only did you endanger his life, you endangered everyone else's life that was on that road.
And I apologize. I send my deepest apologies to this officer. I'm truly sorry. I'm just happy that I pray every day that he wasn't, severely hurt. I pray every day he wasn't severely hurt and he was able to return to work. I understand that he was doing his job. I understand he's an officer of law. I understand.
Brianna's tearful apology wasn't enough to keep her out of jail.
So if I see you again, we're not going to have a discussion. You're going to know what the sentence is going to be. You understand that? The court, having reviewed the probation department's report and recommendation, recognizing the advisory nature of the guidelines and recognizing its discretion, having reviewed the facts and circumstances of the case, the charges and the defendant's history. Ms. Smart, as it relates to count 1, fleeing, eluding, 3rd degree, count 2, resisting and obstructing a police officer causing injury, count 3, assault with a dangerous weapon, you're sent to 2 years probation, 365 days jail, 56 days credit. As it relates to count 4, driving with your license suspended, 93 days jail.
Although Brianna appeared devastated by the sentence, it was far less severe than the life sentence she could have faced if the officer hadn't survived. The next officer wasted no time in using force against a patient with schizophrenia. On January 15, 2020, employees at an AT&T store on Main Avenue reported a customer yelling at staff and waving a knife, prompting Norwalk police to respond. When asked to leave, the man attempted to steal a cell phone, but the clerk managed to retrieve it. The suspect, identified as Solomon, then called for a rideshare service, got into an argument with the driver, and slapped him. After the driver exited the car, Solomon stole the vehicle, leading police to initiate a chase.
Moving left off 43.
Car! Get out of the car! Go to taser!
State police pursued Solomon on I-95 North from Norwalk to West Haven, where he crashed into several vehicles, including police cruisers. The chase ended when he exited at the exit 43 ramp and came to a stop under the Campbell Avenue Bridge.
I got the knife! It's on the hood! Pull my...
As the police officer shouted commands, a trooper broke the car window and retrieved the knife from a different angle. What the trooper did next was truly shocking.
Got a knife! Drop the knife! Drop the knife!
Trooper Brian North claimed he fired his weapon to protect other officers, but the state's inspector general determined the firing was not justified. His trial began on March 4th, 2024. When North testified on March 8th, he stated that he fired at Solomon because he believed his fellow officers' lives were in danger. What stands out, however, is that North thought a group of armed officers could be threatened by a 19-year-old armed with only a knife.
Now, sir, you were asked a series of questions about you firing your weapon in this towards Mr. Suleiman. Please describe again why you fired your weapon that day.
It was to protect the West Haven officer and Trooper Jackson from the threat of imminent death or serious physical injury.
And you were just shown a series of still photographs that included Trooper Jackson's body-worn camera. Do you recall seeing those?
Yes.
And again, your decision to use force the way you did was based on what?
It was based on what I was perceiving at the time.
Throughout the trial, the lawyers thoroughly examined the events leading up to Solomon's demise, using video footage and testimony from the police department to analyze the case further.
Who was in charge?
There was no one person in charge.
And who made the decision to break the passenger side window?
It was a West Haven officer, Officer Rappa.
Did that decision change the overall situation?
Yes, once the glass of the window was broken, Mr. Suleiman, it startled him, and he rapidly escalated it.
Prior to the breaking of that window, what was Mr. Suleiman's state?
He appeared to be unconscious and unresponsive.
We watched a video of you interacting with Trooper Richter and Sergeant Kiley. Do you recall that?
Yes.
The prosecution pointed out contradictions in North's initial statements after the incident, noting that while he ordered Solomon to drop the knife, he simultaneously ignored the fact that he had already fired at him 7 times.
So we're not trained to reassess after each shot. We're trained to reassess after each use of force, which would be an engagement. So that brief series of shots you would then reassess after that.
And Attorney Dylann had asked you, if I'm quoting correctly, did you fire as many times as you wanted to? My question is, how many times did you want to?
There was no number. It was just whatever I thought was necessary to stop the threat at hand.
And then you use the term reassess. At what point would then you have the ability to reassess?
Immediately following being fired.
You were asked questions about the fact of glass, correct?
Correct.
What impact does firing a weapon when through glass have on the shot?
Objection, no foundation.
The officer stated that he wasn't trained to evaluate the situation after firing his weapon. He also explained that his actions were influenced by the information they received, which indicated that Solomon was armed and had been involved in a carjacking.
That if that West Haven officer was not going through that window, but was standing outside as is shown in the video, it would not be objectively reasonable to shoot that at Suleiman, right?
Objection, Your Honor, that's speculation.
He's asking, he had him read the state police criteria there, and I'm asking him if no one's going into that car, it's objectively unreasonable to shoot the driver.
Can we just do it one step at a time?
Sure.
When asked whether using his weapon was an objectively reasonable response to the situation, the officer remained silent, unable to justify the use of deadly force instead of attempting de-escalation.
Is he guilty or not guilty of the lesser included offense of criminally negligent homicide in violation of Connecticut General Statutes 53A, 55, with which he stands charged?
Not guilty.
Does the court accept this verdict?
Yes.
The jury may be seated. Ladies and gentlemen of the jury, please listen to your verdict as it is accepted in order recorded by the court. You, ladies and gentlemen of the jury, each of you do say unanimously that the defendant is not guilty of the crime of manslaughter in the first degree with the firearm in violation of Section 53A, 55, paren A, paren 3, and Section 53, 55A of the Connecticut General Statutes as outlined. You, ladies and gentlemen of the jury, each of you do say unanimously that the defendant is not guilty of the crime of the lesser included offense of manslaughter in the second degree with the firearm in violation of Connecticut General Statutes 53A, 56, paren A, paren 1, and Section 53A, 56A of the Connecticut General Statutes as outlined. You, ladies and gentlemen of the jury, each of you do say unanimously that the defendant is not guilty of the lesser included offense of criminally negligent homicide in violation of Section 53A, 55 of the Connecticut General Statutes as outlined.
The Milford jury acquitted Trooper Brian North of all charges, despite significant public disapproval and widespread belief in his guilt. After 2 weeks of testimony and several days of deliberation, the jury delivered a verdict that brought the trial to a close. In April 2023, Donald Wright stood before a prominent judge, facing charges for one of the most heinous crimes imaginable.
Up next, we have people in the state of Michigan versus Donald Wright, file 22-6356FH. Mr. Wright, we are providing public access both in the courtroom and also online. We have Mr. Wright here with his lawyer, Mr. Gilbert, prosecuting attorney, Ms. Goodrich, and Agent Fagan from the Department of Corrections here for Agent Tuday. And we're here for sentencing on a charge of assault with intent to commit sexual penetration, 10-year felony. Mr. Gilbert, have you had a chance to review the pre-sentence report with your client?
Oh, we have, Your Honor.
Any additions or corrections?
There was just one correction, Your Honor, on the first page of the valuation and plan, the third paragraph down.
This man has committed one of the most horrific acts possible, and he will face the consequences for his actions. However, his behavior in this setting might make you see things differently.
In describing my client being adopted, it says Dante was adopted. The second sentence of the third paragraph, Dante were adopted by the Wrights. That should be Donald was adopted by the Wrights because Dante is his brother.
Well, it says he and his biological brother, Deontay, were adopted by the Wrights. Did the Wrights adopt them both?
Oh, I misread that, Your Honor. My fault. I misread it.
Okay,
That's correct. Yeah, that is correct.
No worries. The advisory guidelines are at 5 to 23 months for any scoring challenge.
I did, Your Honor. I didn't think she scored at 10. I understand that actual treatment is not necessary on OB.
His lawyer is attempting to divert the judge's attention with irrelevant arguments, but the court is focused on one purpose that day, holding Donald Wright accountable for his crimes, and that's exactly what will happen.
Actual treatment is not necessary on OB. For psychological damage, but I did, when reading through the reports, I didn't see whether there had been any claim of that, and so I'm questioning OB4.
That's the aspiratation?
Yes, transportation. I know that there was a car involved, but I don't necessarily, in my reading of it, think that it was to another place of greater damage, or that the young lady was held longer than to commit the offense. So I was questioning OB8. I thought that she was.
Thank you. Ms. Goodrich, we'll take them one at a time here. OB was scored at 10 points for serious psychological injury. The defense objections that should be scored at 0. Your response to that?
Your Honor, it does talk about, without having the victim have to testify, it does talk about in the agent's description of offense how she delayed reporting due to her fear as a result of that incident. I think that the description of the offense reflects the psychological trauma that she went through.
Do you know if the victim's intending to make a impact statement today?
She is.
I mean, based on what's in the pre-sentence report, I would not score it because the fear during the offense does not support that score under the case law.
Next, the victim steps up to share her story, and it's so emotional it might bring tears to your eyes.
Go ahead and tell me anything that you wish me to know before I sentence Mr. Wright.
Okay. I would like to say that it strongly impacted the way I live my life every day now. I feel like I can't walk alone at night or anywhere alone without feeling like someone's gonna do something to me. It hurt my mental health badly, and I did hurt myself because of it. And during that, I hurt the people around me as well. And I can't bring myself to walk alone anywhere. And the way I see people before isn't the same way I see them now. Like, I can't hang out with like my guy friends anymore by myself. I don't even trust hanging out with my girlfriends by myself anymore.
Men like this deserve to be locked up for life with no chance of parole. Unfortunately, her heartbreak doesn't stop there.
I don't really trust older family members anymore because of it. And I think he deserves the maximum amount he can get because he's a grown man and I was 15 and he knew better than what he did.
Thank you.
I'm Jessica Berville, her mother.
This was really bad. Really bad. We spent sleepless nights with that little girl. She'd hurt herself. She cut herself. She tried to commit suicide.
Do you think this was the only pain this man caused? You're sadly mistaken. He brought even more suffering to this family than you can imagine.
I mean, I didn't even know what to do. It was so bad. I didn't even want to leave her bedside.
It was that bad. I made her sleep on the couch so I could hear if she moved to make sure that anytime she needed me, I was there. So I just wanted to make sure that nothing will ever happen to her again. I can't really prevent it, but I will try my hardest to be there for her in anything or something like this. It's not the first time it's happened to her, and it's bad that it happened again.
What's coming next is sure to make your blood boil.
It sucks to have to deal with this all over again with her.
Pretty obvious that cognitively he's not where he should be. I do believe that probably played a major role in this case, in not understanding the consequences of what was happening or how severe the conduct was. So I do ask the court to take that into consideration. And as I said, it's obvious that I've been thinking about that from the beginning due to my request for the forensic. Even though he passed, that there was issues, and I think these issues existed and are part of the reason we're here. Thank you.
Now the defendant steps up to speak, and let's just say things aren't going to go well for him.
Yes, I would like to formally apologize to the courts, to the victim, her family. I'm sorry that I did that. I was young, and upon getting released, whether it's from here or whether I go to prison, I'm looking for guidance. And
The judge proceeds with announcing the charges.
Case, the defendant is 21 years old with no criminal history. He is unemployed with a high school degree. The recommendation is 23 months to 10 years with credit for 347 days. We did have a sentencing agreement to a county jail cap thinking 5-year probation due to the defendant's young age, and that the no contact would continue for those 5 years to assist the victim in feeling safe. However, it criticized court's decision.
Thank you. Well, Mr. Wright, you're here for sentencing on assault with intent to commit a penetration. It's a reduced charge from the charge of criminal sexual conduct in the 3rd degree.
This reckless offender believes he can escape accountability for his actions, but all those illusions are about to be destroyed.
You confessed to the police before you even entered a plea here. You confessed to the police that you had sex with this underage victim. So your guilt on the CSC 3rd is pretty evident. And the victim describes further, although you didn't confess to this part, that this was a forcible and under the threat or perceived threat of a you had in the car, and she was fearful. Of course I'm going to sentence you to prison.
The judge, though firm, remains mindful of his responsibilities.
That does go beyond what the plea agreement was, which included a sentence agreement for a county cap. So if you wish, you can withdraw your plea, and then you can go to trial on the CSC 3rd. I'm going to give you a minute to talk with your attorney and see if what you want to do, if you want to go forward with the sentence I announced.
Would the court consider possibly maybe adjourning the sentencing, because we know this would give me an opportunity to sit down with them?
Well, let me talk. I want you to talk to him first. Well, Mr. Wright, it's a big decision with a lot of factors, so I will go ahead and continue this sentencing then to May 9th at 3 p.m. Mr. Wright, I don't want you to make a decision right now that you regret in 5 minutes or 5 days or 5 months. I want you to take some time to think about it. So we'll come back on May 9th and give you time to talk to Mr. Wright. Okay?
Donald Wright received the punishment he deserved, a lengthy prison sentence for the unimaginable crimes he committed. In February 2018, Blandine Yvonne Idumbo, just 18 years old at the time, was involved in a tragic incident at a Best Western Plus motel on Manitou Drive in San Antonio, Texas. She and 20-year-old Tarek Mike met with 25-year-old Robert Patterson and his girlfriend to discuss a scheme to steal cars and sell their parts. During the meeting, Mike unexpectedly pulled out a weapon and fired twice at Patterson, resulting in his immediate loss of life. He also fired at Patterson's girlfriend, seriously injuring her, though she survived. After the incidents, Idumbo and Mike fled the scene. Idumbo was later arrested and charged with capital murder. She denied responsibility for Patterson's demise.
Hearing began with a denial from the defendant.
No, I did not pull that trigger.
20-year-old Blandine Idumbo is talking about a fatal shooting that occurred at the Northside Motel in 2018. She and 20-year-old Tariq Mike were at the motel planning a car theft and parts chopping scheme with another couple, according to police. The plan went bad, they say, and Mike shot 25-year-old Robert Patterson to death.
He's standing over Robert for about 3-4 seconds, and that's when 2 shots went off.
Despite her denial, the teen was eventually convicted and sentenced to 20 years in prison. Before the sentencing, her mother tearfully apologized, saying she felt she had failed her daughter.
Mike were at the motel planning a car theft and parts chopping scheme with another couple, according to police. The plan went bad, they say, and Mike shot 25-year-old Robert Patterson to death.
He's standing over Robert for about 3-4 seconds, and that's when 2 shots went off. And Robert didn't move at all.
She stated that Mike also fired at and critically injured Patterson's girlfriend before they fled the scene in her car.
Shocked because somebody who I thought was a friend to me, I never thought that he would just mercilessly execute 2 people.
They were eventually arrested and charged with capital murder. Mike pleaded guilty to a reduced charge of murder and received a 30-year prison sentence, while Idumbo faced charges of aggravated robbery.
It is the order of the court that you be sentenced to 20 years confinement.
During the hearing, Idumbo's mother gave an emotional apology that moved her daughter to tears. In a recent hearing with Judge Fleischer, a young woman faced extradition to Tennessee on fraud and identity theft charges. She firmly denied the accusations, saying she was a victim of identity theft and had never been to Tennessee. She also voiced concerns about the risks of being sent to a state where she had no ties.
Okay, so it looks like you're wanted somewhere. I don't know where.
One out of Rutherford County, Tennessee. Warrant was issued out on September 9, 2024. For 3 charges: theft of property $60,000 to $250,000, and identity theft of at least 10 counts, and a fraudulent use of a $60,000 to $250,000. I will obviously be opposed to a bond. She already waived on November 20th.
Does she have an open local as well?
No, Judge.
Why did it get reset so much?
I do not know. Well, it's carried over.
Oh, it's carried. Okay. Ms. Oko.
Judge, so Ms. Burnett does tell me that she's a victim of identity theft. So she's believing that this is just stemming up from someone else using her identity to do different things that she has no, and she did write a report on this, I believe, a few weeks before this charge came down on her.
So you're telling me that the felony capias and the $60,000 to $250,000 theft of property and the 10-count identity theft, the fraudulent use of a debit card of $60,000 to $250,000, all that was someone else?
Yes, Judge, that's what I'm being told. Ms. Burnett, go ahead.
Yes, so last year I already filed a police report against Cash's bond. He stole my social security number and he used it to open up an electricity bill in my name. And I also have other charges against him regarding burglary of an habitation. He broke into my house and stole my phone, and he stole money from me. And he also put his hands on me. So I'm guessing these charges are from him. I've never been to Tennessee before in my life.
Judge Fleischer acknowledged her concerns, but explained that the court's job was only to confirm if the extradition request was valid, not to decide her guilt or innocence.
How do we verify that?
I've never been to Tennessee.
No, well, I mean, the problem is that, you know, a lot of people tell me something, right, when in fact the sky's blue instead of purple. People come in here, tell me, yeah, the sky's purple. Man, this pig was blue. And what? Pigs are pink. Yeah, man, this pig was blue. You got to believe it.
I have proof of being in Houston on those dates, whatever dates they're saying.
Okay, so I guess, I mean, I could have you get with the lawyer somehow, you guys. I mean, we've given you a lawyer. She's here to help you out in whatever manner that they can. I would suggest that you guys get together to figure out how. That's a lot of baggage. I mean, that's.
Yeah, I was working with the assistant district attorney. We were pressing charges on him. So I didn't know he was out of jail. He was supposed to be in jail still.
I mean, I guess I can have you guys talk about it. You've already waived, right?
Yes, Judge.
Do you know if Tennessee's going to come get her?
As far as I know, they are, unless they tell me different from 5 days ago. But the waiver was sent on the day she signed with the magistrate, so they would have told me.
You basically have 9 days left.
With the nature of the offenses, they can be done remotely because their identity, the very nature of the offense is that they could be done remotely. And if it was similar to conversion for the theft of property, they could have occurred from here, but the impact in Tennessee.
And here's the deal. We give the other jurisdiction 14 days to come get you. You've already been sitting in there and you waived already. So they only have 9 days to come and get you. If they don't come within that time, Harris County releases you. So, but I'll tell you, even if Harris County releases you, that warrant is always going to remain out there until you go back to Tennessee and try to take care of it one way or the other.
I don't mind going to Tennessee. I have transportation. I just don't want to remain in custody.
I know, no one does, right? But
and I was told there was some type of video, so I don't see how it could be electronically done.
Also, it is worth noting that I never.
We don't know. We're speculating. We don't know.
The judge told me when I went to court on Wednesday night.
What was on video?
They said they have a video of me and Cassius Bond in Tennessee.
Okay. Just give me a second, Jake. Okay. I don't get access to any of that. Right here, all we were worried about is identity. Are you Naomi Burnett? And if you are, we establish the identity, that the charges are proper. If so, how do we go forward? A lot of times we let someone bond out if the person is not a danger, right? And we know that they're going to go back. But we don't know much about you, you know.
I have no criminal record. I have a degree, a bachelor's degree.
So if it's a matter of verifying the identity, if she's contesting identity, then she can withdraw the waiver and we can go for a governor's warrant. Or
no, I don't think she's contesting identity. She wants a bond, is what she wants.
Like I said, with the amount in the offense, with $250,000 on both theft of property and fraudulent use of credit card, and the fact that it's 10, which would be a third degree or second degree felony here, is that I'd be opposed with the sheer amount that is being alleged.
Yeah, one of the other things is that the higher level of charges, the more unlikely it is that we're going to give a bond, because the higher likelihood a person has of taking flight and not going back. So I don't know at this time whether I'm comfortable in setting you a bond. Okay. I don't know what connections you have here. I don't know what connections you have there. And the last thing I want to do is lose you, because that's a lot of stuff to answer to. And we want to make sure that, you know, whoever it is that has those charges is able to answer up to those charges. So
I also say that I already have a lawyer ready in Tennessee.
So what we can do here, what we can do is I can have you talk with Ms. Oko, figure out if there's some way that you can show that it's someone else, right? And if so, then we can talk more. Okay. But understand that I can't just take your word for it, you know?
Understand.
Okay, so
even if I have police reports on him for already stealing my identity.
I'll let you talk with Ms. Oko, see what you can formulate, craft some kind of plan so that they're satisfied and I'm satisfied, and then we'll go from there. Okay. It's not a no. I mean, it's an uphill battle, but it's not a definite no at this point. Okay.
Understand.
Okay. Yeah. All right.
He told her that the right place to challenge the charges was in a Tennessee court. On August 18th, 2016, a tragic event unfolded in Grand Rapids, Michigan. 16-year-old Savin Schmoose ended the life of his 18-year-old half-sister, McKenna Hilton, in a shocking act of violence. Savin strangled McKenna inside their father's apartment, then placed her body in her car and drove it to another part of the township where he abandoned it. A few hours later, a dog walker discovered McKenna's lifeless body and alerted the authorities, prompting a police investigation.
Who her family says she lost, Siobhan Schmuss, now 17, was 16 when the crime happened. He was mocked when given the chance to speak in court.
During one of Savon's court appearances, Kent County Assistant Prosecutor Vicky Sells requested the judge to deny bail. Savon's father, David Schaas, who was present in the courtroom, shouted words of encouragement to his son as the bailiffs escorted him away. Further investigation revealed that in 2010, David Schaas had pleaded guilty to taking a photo of McKenna, who was only 12 years old at the time, while she was showering. Due to his previous convictions for drug and illegal weapon possession, David Schaas faced 15 years in prison. Savon, who was 10 years old at the time, wrote a letter to the judge asking for leniency in his father's case. Ultimately, David accepted a plea deal.
It was so heinous, it was premeditated, it was so hateful, so evil. He doesn't deserve a second chance.
In 2017, Savon Schmuss pleaded guilty to murdering his sister McKenna. During the sentencing hearing, McKenna's mother, Stacy Hilton, gave an emotional victim impact statement directed at Savon. Stacy expressed her deep anger and said she would never forgive him for taking her daughter's life. She added that she hoped Savon would leave prison in a body bag.
Doesn't get one, we don't get one. He doesn't deserve one.
Although Savon expressed remorse for his actions through his attorney, Stacy Hilton was doubtful, saying she didn't believe his apologies. She spoke about the deep pain of losing her beloved daughter, describing the irreplaceable void McKenna's demise had left in her life. Savon's father, David Schmuss, read a Bible verse about the enduring power of love. The hearing concluded with Savon being sentenced to 40 to 100 years in prison. As the sentence was announced, David wept openly, but Savon remained silent. Harmony Montgomery, a young girl from Manchester, New Hampshire, tragically lost her life at the hands of her father, Adam Montgomery, in December 2019. In February 2019, Harmony was placed in the custody of her father, Adam Montgomery. Despite his criminal history and limited interaction with her, Harmony's mother, Crystal Sorey, last communicated with her daughter in the spring of 2019. After unsuccessful attempts to contact Harmony, Sorey reported her missing in November 2021.
5-year-old girl. You treated her in the worst of possible ways, in both her life and in her death. Therefore, the court sentences you as follows. On charge ID 2027112C, the charge of second-degree murder, you are sentenced to the New Hampshire State Prison for not more than life nor less than 45 years. That sentence is stand committed. That sentence is consecutive. All of these sentences, I should say now, are consecutive to each other, as well as consecutive to docket 216-2022 CR 577, which are the sentences that you're currently serving. Additionally,
by then, Harmony had been unaccounted for over 2 years. Investigations revealed that on December 7th, 2019, Adam Montgomery fatally assaulted Harmony following a minor accident. He then concealed her body for several months before disposing of it in March 2020. Despite extensive searches, Harmony's remains have not been located.
You're to participate meaningfully and complete any counseling, treatment, or education programs as directed by the correctional authority or probation, parole. Law enforcement agencies may return evidence to its rightful owner. You are ordered to be of good conduct and comply with all the terms of this sentence. This is also consecutive to the second-degree assault charge in the docket ending in 20. That is charge ID 1937947C. Do you have any questions about that sentence?
Nope.
On charge ID 2027113C, falsifying physical evidence. On this charge, you are sentenced to New Hampshire State Prison for not more than 7 years nor 3.5 years. This sentence is stand committed, consecutive to all of the other charges that I'm about to read you, as well as consecutive to the second-degree assault charge in the docket ending in 20 and the sentences that you are presently serving. You do have the obligation, as with the other sentences, to meaningfully participate in programming as directed by the correctional authority or probation, parole. You're ordered to be of good conduct and comply with all the terms of that sentence. On the charge of tampering with witnesses and informants, you are sentenced to the New Hampshire State Prison for not more than 7 years nor less than 3.5 years. Again, these sentences are This sentence is consecutive to the additional sentences that I've read to you in that I'm reading to you in this case, as well as docket ending in 2-0 and the sentences that you are presently serving. You have the same obligations for charge. On this charge, you are sentenced to the maximum penalty of 12 months at the House of Correction. All of this sentence is suspended for 25 years. If it were to be imposed, it would be consecutive to the sentences that I read to you. And on this charge, you will also have the provision of a no contact order, and that is no contact with the Sorey family, the Miller family, and the Rafferty family.
In February 2024, Adam Montgomery was convicted of second-degree murder, assault, witness tampering, falsifying physical evidence, and abuse of a corpse.
That sentence is also consecutive were it to be imposed to all of the other sentences in this case and the sentence you're currently serving. On the second-degree assault charge ID 1937947C, you are sentenced to New Hampshire State Prison for not more than 8 years nor less than 4 years. This sentence is consecutive.
He received a cumulative sentence totaling a minimum of 56 years in prison, effectively ensuring he spends the remainder of his life incarcerated. In July 2022, 15-year-old Timothy Ferguson was found deceased in his family's Norton Shores, Michigan, home, weighing only 69 pounds. An autopsy determined he died from dehydration and extreme emaciation due to malnutrition and starvation, with the medical examiner ruling his death a homicide. His mother, Shonda Vander Ark, was arrested and charged with his murder and first-degree child abuse. In December 2023, a jury found her guilty on both counts. During the trial, evidence revealed that Vander Ark subjected Timothy to severe abuse, including starvation.
We know who you are. That's the way that I'm going to honor him. You don't win, because justice, thank God, in this case prevailed. I can't even imagine if you had been able to resuscitate him. He'd be still suffering. So if there's anything I'm grateful for, would be that he finally passed away so you couldn't continue to torture him like you did. It's a sentence of the court. First says to count 2, child abuse in the first degree. Court sentences you 50 years to 100 years in prison. Credit for 575 days. Court is exceeding guidelines in this case. The court finds that the amount of torture that I've indicated in terms of the long-term suffering that Mr. Ferguson, Timothy went through justifies on a reasonable grounds to depart from the guidelines. Used to be the standard was the guidelines. If the guidelines didn't take into consideration all the elements, I don't think they would take into consideration the amount of absolute systematic, consistent torture that you engaged in here. I think that's enough reasons to justify departing from the guidelines.
On January 23, 2024, Judge Matthew Cassell sentenced Vander Ark to life in prison without the possibility of parole for first-degree murder and an additional 50 to 100 years for first-degree child abuse to be served concurrently.
There's a $68 state cost, $130 crime victim rights assessment. As to count 1, felony murder. It's a sentence of the court. You serve a term within the Michigan Department of Corrections for the rest of your natural life without parole. Again, there's credit for 575 days that you've already served. There's a $68 state cost. The crime victim assessment fee has already been assessed, and the court is going to assess a $450 public defender fee. Ms. Vander Ark, you have a right to file an application. You have a right to file an appeal Request for this, if you are unable to afford an attorney, one will be appointed to a public expense. Request for assistance of a lawyer must be made within 42 days from today's date. Clerk is handing you a form that you must complete, return to the court in that 42 days. Mr. Roberts.
Judge, just briefly, I believe you did indicate you would order that $5,000 in restitution.
Oh, I did. Thank you, Mr. Roberts. The court will order $5,000 in restitution at this time to the Michigan Department of Health and Human Services, with a caveat that Mr. Johnson, you can certainly, if after the documentation, you can certainly ask for a restitution hearing and to contest that amount.
Thank you, Your Honor.
Anything else for the record, Mr. Roberts?
No, thank you, Judge.
Mr. Johnson?
No, sir.
All right, we're adjourned.
The judge described her actions as intentional and systematic torture. Timothy's older brother, Paul Ferguson, was also implicated in the abuse. He pleaded guilty to first-degree child abuse and testified against his mother. On February 26, 2024, he was sentenced to 30 to 100 years in prison. Zachary Davis was an unusual teenager, but no one anticipated that he would one day use a sledgehammer to end the life of his mother and then set their house on fire while his older brother was asleep inside. What's even more shocking is that he was only 15 years old when he committed the crime.
You laugh when you were hitting her?
Yeah.
Why did you laugh?
I just thought she deserved.
Let's move to the Sumner County Criminal Court in Gallatin, Tennessee, where 17-year-old Zachary Davis is set to be sentenced. As a child, Davis was a reserved boy with a clear history of mental health issues. His mental state deteriorated after his father passed away in 2007 when Davis was only 9 years old, leading to diagnoses of schizophrenia and depressive disorder. Normally quiet, Davis became increasingly withdrawn over time.
We've heard talk about you hearing voices when no one's there. Do you hear voices then?
Yes.
Can you tell the judge? Do you recognize that voice?
He often spent his time researching serial killers on his phone and playing violent video games, all of which were significant warning signs. Still, nobody anticipated the level of violence he would display on August 10th, 2012. That day, Davis, his mother, and his 16-year-old brother Josh had gone to a movie together. Upon returning home, his mother, Melanie, went to bed early at 9 p.m. While she was asleep, Zachary Davis went to the basement, got a sledgehammer, and entered his mother's room. He then fatally bludgeoned her, striking her nearly 20 times.
I could just hear the hammer hitting her head.
And what did it sound like?
There was this wet thumping sound.
After the attack, covered in his mother's blood, Davis shut her bedroom door, then went to the family game room, where he poured whiskey and gasoline and set it on fire, while his brother was still sleeping. He closed the game room door and left the house. His original intent was for his brother to lose his life in the fire, but because he had closed the door, the fire didn't spread quickly. The fire alarm eventually woke his brother, who, after attempting to find their mother, discovered her lifeless, bloodied body. Davis was arrested, and throughout his appearances in the media and in court, he displayed a disturbing lack of remorse.
What makes you laugh? Yes, thanks, very good. Give me an example. Well, I was laughing. You were what? I was laughing when I
With his peculiar behavior, he gave an explanation for why he murdered his mother.
Your mother?
Yeah.
And why did you?
She wasn't taking care of my...
Ultimately, Davis was convicted of first-degree murder, attempted first-degree murder, and aggravated arson. He was automatically sentenced to life in prison for the first-degree murder charge and received an additional 15 to 25 years for the attempted murder and arson charges. In Tennessee, a life sentence requires a minimum of 60 years served, with eligibility for parole after 51 years. This means Zachary Davis will be in his mid-60s before he could potentially be released on parole. In February 2022, Leticia Gonzalez was involved in a tragic accident in Holland Township, Michigan, where her car went off the road and sank into an icy retention pond. Her 3 young sons, who were strapped into car seats, drowned in the crash. Gonzalez escaped with minor injuries. Investigators later found that she had taken methadone, a medication for pain and addiction treatment, earlier that morning, which impaired her ability to drive safely. In August 2023, Gonzalez pleaded no contest to charges, including operating while intoxicated, causing serious injury, a felony, and 3 misdemeanor counts of moving violations causing death. During her sentencing, she expressed deep remorse.
I've lived with survival guilt since February 17, 2022. And I continue to hate myself every day, Your Honor. But I want to apologize to my kids' family and to the community, and most of all to my kids, because life without them has been difficult. I just pray that they know that I'm nothing without them, and that it was just an accident. They were the reason that I chose to change my life, and I chose to never look back and be seen in another courtroom in trouble. Being their mom was all I ever wanted. Each day I tried coming to terms with my reality, but my reality is just a nightmare. And that day seems to stick with me, with depression and flashbacks from each and every day. I often find myself asking God why, because the hurt, it's indescribable. I love them so much. I love you boys to the moon and back. With everything I have inside me, but Your Honor, I'm willing to accept the responsibility for my actions. Because as a mother, I feel that I have failed. But even though my life has changed, I'm asking for mercy. I'm crying out for help to understand that this mentally and physically. Because I would like to grieve. I'm living in pain and remorse every day. And I just want my boys to know that I'm sorry for everything. And if I could give my life and change places, I swear I would. Life without them will never be the same, Your Honor. I lost everything I ever needed, and I hate myself so much. I've been sentenced to life without them for the rest of my life, so I'm asking for forgiveness. And also to my 3 boys that lost their lives. But yet here I stand, still asking you for mercy.
The judge acknowledged her regret, but pointed out that this incident was part of a larger pattern of substance abuse. On September 25, 2023, Gonzalez was sentenced to 2 to 5 years in prison, with a minimum of 24 months and a maximum of 60 months.
Suggesting that anything that happened here was intentional at all. By the same token, when the court looks at the pre-sentence investigation report, it indicates that you had obtained illicit methadone on multiple occasions from this other individual. And unfortunately, your children were in the motor vehicle when you did that. So this was not a one-time situation that you succumbed to pressures or desires to use drugs. Rather, this seems to be a pattern, and unfortunately, your children paid the ultimate price for that. And then historically, when the court looks at your contacts with the justice system in all the arenas, back in 2016, 2017, and preceding and post, you had your parental rights terminated to at least 2 children, and I think 3 now. And that was for neglect and drug use and abuse situations. So this has been a long-term pattern of placing your children at risk because of drug usage, and now you have lost 3. So therefore, the court does believe that a substantial sanction is warranted because this was not a one bad night situation, which we had a horrific tragedy. But as he sentenced of his court on the OWI causing serious injury, that he turned over to the MDOC for a minimum of 24 months and a maximum of 60 months. On all 3 counts of motor vehicle causing death, those are misdemeanors. The sentences will be the same, 365 days in jail, credit for 71. All of these are concurrent. Must pay state cost, crime victim costs, and D&A fees that are required by statute. This is the final sentence. You need to file an application to the Court of Appeals regarding your conviction and sentence. If you're unable to hire an attorney, this court will appoint one to represent you at public expense. You need to fill out the paper. People provided, return it within 42 days. The sentence is within guidelines, and prison has been imposed due to the reasons I have articulated.
She She also received a concurrent jail sentence of 365 days for each misdemeanor charge, with 71 days of credit for time already served. In March 2016, Alyssa Johnson, 23, was found lifeless in her Dongan Hills apartment on Staten Island. Initially, there were no obvious signs of trauma, but the medical examiner later determined the cause of death to be blunt force trauma to the head and neck, ruling it a homicide. Her boyfriend, Jeffrey McDonald, also 23 at the time, was arrested and initially charged with assault. Following the medical examiner's findings, the charges were upgraded to manslaughter.
So sorry for the pain I caused you. Sorry. This was the love of my life.
I just think the case can be summed up in 4 words. Alyssa Johnson is because you, Mr. McDonald, are a coward. The autopsy reveals that Ms. Johnson had blunt impact injuries to her head, neck, torso, and extremities. The combination of her injuries and level of intoxication indicate that she was virtually defenseless. She didn't bump into a wall and knock the mirror off. She didn't fall and hurt her face off the bed, or her neck, or her back, or her side, or her arm, or her leg, or any other place that she has bruising and hemorrhaging. She wasn't snoring when you picked her up, unlike what you told the police. She was probably. You batted a defenseless woman who weighed 107 pounds. You raised your hands to a woman. That makes you pretty low. In my book, that makes you a coward.
In 2017, McDonald pleaded guilty to second-degree manslaughter as part of a plea deal, resulting in a sentence of 4 to 12 years in prison. During sentencing, Judge Mario F. Matei criticized McDonald's lack of remorse, describing his actions as depraved and despicable.
But just when you think someone couldn't sink any lower than beating a 23-year-old woman to death, you proved everyone wrong. Before you left the apartment, you propped Miss Johnson up against the bed and took her picture. It is one of the most disturbing pictures I have ever been unfortunate enough to see. It's upsetting to think that you would take a picture of someone in that condition and she looks as though she's already passed. It's disturbing to think that you left a human being in the state she was in and just went out after taking a picture that you posed. Your lack of compassion is palpable. You don't have an ounce of decency in your body. There are no words that can describe how depraved and despicable your actions.
In 2019, a state parole board denied McDonald's request for parole, citing concerns over his inability to explain the reason behind his violent actions. Daytona Beach police officer Joshua Massaro was involved in a confrontation with Marvin Jones, who was struck 5 times. Jones's girlfriend, Aviana Bailey, was also injured during the incident. The young pregnant woman was left paralyzed from the chest down. After this life-changing ordeal, she filed a lawsuit against the police and the city.
Playing, fumbling, doing something with in his lap. There's none of this. There's none of this. It's this. And he's looking at me the whole time. And then it happens.
What happened?
He sticks the window and points it at me.
Okay. How does he stick the gun out the window?
If I'm sitting in the driver's seat, where would so he just went just like that.
Okay.
And it was between the mirror and the A-post.
Okay.
Well, actually, if I'm driving.
Exactly.
I'm sorry. If I'm driving, the driver's side the door is here. So he did this.
Okay. Because you had him moving.
Excuse me.
Further into the passenger compartment.
No, that was completely. Right. That was my mix up in the side. It was the right side that he did it with, and then he put the gun between the.
Officer Joshua struggled to keep his story consistent, and it's surprising to see how casually he approached the deposition.
You said right side again.
Left side. I'm dyslexic.
Are you dyslexic?
No, I'm sorry. I didn't. That was a bad joke.
Do you recall how many rounds?
Just one at that time.
Okay. And where did it strike?
The hood and windshield area, right in front of him.
And how many muzzle flashes did you see in total at scene 2?
At least the initial, at least 1, and possibly 2. I can't count them. I can't tell you how many exactly.
The officer's attitude revealed his inflated ego as he treated the situation far too casually. It was evident he didn't grasp the severity of how Bailey's life had been completely changed. She was no longer even able to care for her baby.
I was committed to engaging him. And I did that, at which point my ankle rolled off the curb and I fell on my back.
Okay.
I was falling, and so somehow the jammed from limp wristing it.
Okay. That were fired at you, or you saw several muzzle flashes?
Yes.
How do you define several?
Check the form.
One or two? Two, probably.
Okay. Several's not one.
Yeah.
What we agree to that? Do you mean is several more than two?
Check the form.
I would say two.
Okay.
So we'll say a couple.
Okay.
When investigators questioned Joshua about the tragic incident, he downplayed the seriousness of the situation, choosing to joke rather than respond responsibly.
In your deposition, you discussed dust. Tell me about that. Or was there dust at scene 2?
Yes.
Tell me about that.
Form.
There was dust at scene 2.
And I understand there may have been dust on the ground, but did the dust become airborne?
Yes, from the suspect's vehicle spinning in the grass, which was dry.
Did the dust settle? Let me say, before you got out of your car?
No.
Okay, so there was still some dust in the air.
Correct.
When did the dust settle?
Still hasn't settled. I guess it never really did. I mean, that I remember.
Okay. Now, before you got out of your car and engaged Marvin Jones, did you know anything about him or his background?
Just the fact that he might have some felony warrants out of New Hampshire.
How did you learn that?
Apparently, somebody called from New Hampshire to rat him out.
Joshua showed no remorse for his actions, and as the deposition went on, his responses became even more unusual.
What threat was posed to the safety of an officer or other person at the point you first got out of your car?
There was none.
Okay. What threat to an officer or other was posed when you first drew your firearm?
There was none.
What threat to an officer or other was posed when you got out of your car, when you took a step towards the Lincoln?
Check the form.
At this point, the defendant's actions.
Okay. Which were what?
Fumbling around on his, making very furtive movements.
Okay.
Kept looking at me.
The attorney questioned Joshua about his troubled past, including his removal from his position as a K-9 officer. His evasive and dismissive answers to these questions were startling.
Did you have your duties as a K-9 handler revoked or rescinded at any point?
Yes, I did.
What happened or why?
Form of objection.
In my opinion,
Yes.
I was doing my job too well.
What does that mean?
It means I was beating the streets and I was catching bad guys.
Okay.
There wasn't a lot of bad guys that got away from me.
Because your dog got him?
Because we got them as a team.
Okay.
And if you have an above average bite ratio, that means you could be using your dog too much.
Okay.
A bite ratio is how many people you apprehend and then how many people you dog bite during that apprehension. So they're saying 30%. So they're saying out of 10 people that you apprehend, you should bite 3 of them, let's say.
Okay.
Which never made any sense to me.
The officer's arrogance made him oblivious to how foolish he appeared. His attempts to present himself positively only emphasized his dangerous and intimidating behavior.
When was your K-9 handler duties taken away?
Late 2011. As a matter of fact, December 23rd, 2011.
Okay. Why is that date stick out?
Worst day of my life. I enjoyed the job. I would have paid the city to come do that job. Tracking down bad guys and finding them and apprehending them.
Did you apprehend good guys?
Never. I take that back. I bet a victim one time because she jumped in front of me. So I did. I bet a victim one time.
Was that another officer?
No, it was a victim, a domestic violence victim.
Joshua's past was filled with poor judgment and instances of excessive force. Attorney Doug Deeper highlighted his disturbing and psychopathic tendencies.
You need supervisor authority to conduct a strip search?
Yes, sir.
Did you obtain supervisor authority before you searched Justin Riddle?
No, sir.
Did you receive counseling or did a supervisor talk to you about that and tell you did that portion incorrectly?
Yes, sir.
March 2011, there was a newspaper article about a lawyer that claimed you used excessive force. Do you recall that incident?
Yes, sir.
Tell me about that.
He was, Roe. He was hammered. He was drunk.
Mm-hmm. Oh yeah, I remember this one. This is the one where you were alleged to have gone in a home without permission, like moved somebody's arm. You recall that incident? What happened there?
I was on K9. We were looking for, they're twins. There's two of them. I forget their names, but we saw one on the bed through the window. And I'm like, that's him. That's him. But this is before I knew he had a twin or a brother. So he had a felony warrant.
The twin did?
No.
One of
them had a felony warrant.
The guilty one, not the innocent one.
So the mother's there, and got the place surrounded, and basically she said, you're not coming in. Well, he's in there. We can see him in there. We can force entry on a felony warrant if we see the person and we confirm it's him. I eat that one. That was my responsibility all day long for not knowing that it's the brother. They do look different. If I had seen his face, maybe pay attention to his haircut.
Did you ever arrest a good guy?
Did I ever arrest a good guy?
Yeah.
Not that I can recall.
So,
in the end, the officer was protected by qualified immunity, but Bailey did receive a settlement from the city. While it won't fix her challenges, it may offer her a small sense of relief. Nikki Sue Ensel wasn't just cheating on her husband. She made things even worse by orchestrating his death. On January 2nd, 2020, a panicked 911 call came in. Nikki Sue claimed she had returned home to find her house on fire and feared her husband was still inside. She told authorities she had been out of town for a few days and only came back after one of her husband's co-workers called to say he hadn't shown up for work.
I was here to check. My husband sent a text message that he didn't come in today, and I've been good 3 days, and so I'm coming here to check. And I walk in, I open the back door, and I walk in the house is smoky. I can't get in the door. It's smoky in the house.
When firefighters arrived, they found the body of 42-year-old Chad Ensel in his bedroom. He was pronounced deceased, and an autopsy was conducted. It was soon discovered that the fire wasn't the cause of Chad's passing. He had sustained multiple injuries from a weapon. Initially, investigators thought Chad might have taken his own life and that the fire was caused by a propane heater. However, further investigation ruled out that possibility. The weapon was found near the bed, not close to Chad's body on the floor. Additionally, evidence of an accelerant in the bedroom confirmed that the fire had been intentionally set. At first, Nikki wasn't considered a suspect, but security footage changed everything. It showed Nikki with a man in several locations around the area. This man was later identified as Earl Howard, Nikki's lover.
That Nikki Sue Ensel and Earl Howard agreed to kill Chad Ensel, agreed to set the house on fire, to collect the insurance benefits and to cover up the murder, and agreed to tamper with evidence by destroying or disposing of that second shell and setting the fire to cover up the evidence of the murder.
Nikki had been having an affair with Earl Howard for some time before meeting him at a motel. Although she denied returning to the house before the fire, CCTV footage proved otherwise. Under repeated questioning, Nikki claimed that Howard fired at Chad during a struggle over the weapon while she waited in the car. Later, her story changed again, and she claimed she had never met Howard before. Prosecutors didn't believe her. Howard, however, told investigators that Nikki was the one who fired at Chad and that he helped by setting the house on fire to destroy evidence. Prosecutors argued that the two had planned the murder to collect Chad's insurance money and run away together. Nikki was charged with conspiracy to commit arson, conspiracy to commit murder, and conspiracy to tamper with evidence. In February 2023, she was sentenced to life in prison with the possibility of parole. In court, she attempted to appeal her sentence.
I get told I need to take a plea deal. It's going to be this way. I don't want to. I want to have my chance.
Nikki's appeal was denied, and she is now serving her sentence in North Dakota. Howard pleaded guilty to multiple charges, including conspiracy to commit murder and arson. As part of a plea deal, prosecutors dropped a murder charge. In February 2022, he was sentenced to 25 years in prison. Next, we delve into the disturbing case of two individuals who shockingly murdered their own grandparents. On April 8, 2017, Gwinnett County, Georgia, was shaken by the brutal murders of 63-year-old Randall and Wendy Bjorga. The couple had taken in their troubled 17-year-old granddaughter, Cassandra Bjorga, and tried to give her a stable environment. However, Cassandra's behavior became increasingly violent and erratic, involving frequent runaways, drug use, and assaults on her grandmother. She also had a tumultuous relationship with her 19-year-old boyfriend, Johnny Ryder, with whom she often fled. On the day of the murder, police were called to an assault in Lawrenceville, where Johnny and Cassandra had attacked Johnny's sister and her boyfriend with a baseball bat and pepper spray before escaping in a car owned by Cassandra's grandparents. This prompted the police to check on the Bjorgas, leading to a gruesome discovery. Randall and Wendy were found deceased, having suffered multiple stab wounds, blunt force trauma to their heads, and slashed throats. The community was appalled by the murders, and Johnny and Cassandra were quickly identified as the prime suspects. The next day, they were found barricaded in an apartment, having attempted to take their own life. They survived and were hospitalized. During questioning, it was revealed that they had planned the murders in advance. Both were charged with the heinous murders of Cassandra's grandparents.
Seems that you're sorry you got caught, that you had people over after. You don't seem to be sorry that you killed your grandparents.
Cassandra Bjorga confessed to the police that she and Johnny Ryder had carefully planned the murders of her grandparents with the aim of concealing their bodies. According to her account, they waited until Randall and Wendy were asleep, then entered their bedroom, restrained them with duct tape, and initiated a savage assault. The weapons they used included a tire iron, a baseball bat, a hammer, and butcher knives, with which they beat and fatally injured the couple. Adding to the gruesomeness of the crime, Cassandra took steps to keep the bodies from being found by sealing the house's windows and doors with caulk to trap the odor of the decaying bodies.
And then we came back to the house.
When you guys left, where'd you guys go to?
We went over to like Kroger or Publix to go get something to eat, and then we went back to the house and we just kind of like chilled there.
Which one?
That was like on Old Peachtree.
After the murders, Johnny and Cassandra ordered takeout and hosted a party at the house with their friends. Cassandra also admitted that they used a significant amount of substances to mask the smell of the decomposing bodies, which remained in the house for over a week.
Things like just seemed different. They didn't look at me the same anymore. Like they didn't, I don't know, it's like the vibe that they have was like, they didn't really know what to do. They didn't really know like how to be around me, I guess. They didn't really know how to talk to me.
The motive for the murders was startling. Cassandra claimed she ended the lives of her grandparents because they were too strict. She also mentioned that they weren't the only targets. She and Johnny had plans to harm Johnny's family and her own mother as well. Both Cassandra and Johnny accepted plea deals, avoiding a trial. They were each sentenced to 2 life terms, with the possibility of parole after 60 years. Their reactions to the sentencing were markedly different. Johnny expressed remorse and apologized for his actions, while Cassandra cried and remained silent, even when offered the chance to speak. They will both be eligible for parole in 2077. Thank you so much for watching. Don't forget to subscribe and hit the notification bell so you can stay updated with our latest videos.